Michigan Supreme Court has ruled Donald Trump can remain on the primary ballot. Multiple groups had pushed for his removal under the 14th Amendment, which bars someone from holding office if he is, quote, engaged in an insurrection. Now, you might remember Colorado's Supreme Court ruled last week that the former president cannot appear on that state's ballot due to his involvement in the January 6th Capitol riot.
Despite meddling in the Michigan election in 2020 by attempting to install fraudulent electors, the Michigan Supreme Court, the highest court in the state, of course, has split from Colorado, ruling that Trump can in fact remain on the presidential primary ballot for 2024. Now, this means it's very likely that the United States Supreme Court will have to weigh in on Section 3 of the 14th Amendment, which bars those who have engaged in insurrection from office, should be the interpretation, or should be interpreted. Now, I should note that after Colorado's decision to bar Trump from their primary ballot, many states, over a dozen, had decided to attempt to do the same, at least 16. Now, courts in Arizona and Minnesota have also ruled against similar efforts to get Trump kicked off the ballot. But for the purpose of this story, let's focus on Michigan and the decisions made by the Supreme Court in that state. Now, before we get back to the current cases, let's briefly revisit how Trump tried to overturn the results of the 2020 presidential election. That'll give you the context necessary to determine how you feel about Michigan's decision here. So as we all know, or should know at this point, his team recruited 16 fake Trump electors to sign a certificate falsely claiming that Trump won the state of Michigan. Trump also was taped in December of 2020, pressuring 2 members of the Wayne County Board of Canvassers to not certify the election results, which of course went toward Biden, providing direct evidence of his role in trying to overturn the vote in Michigan. Now, aside from that, and the fact that you have Colorado and Michigan coming to different conclusions, there were other significant differences between the Supreme Court cases in Michigan and Colorado. So unlike in Colorado, the Michigan Supreme Court didn't actually weigh the issue. It simply declined to even hear an appeal, instead affirming the decision of 2 lower courts to allow Trump on the ballot. The Michigan Court of Claims judge who first got the case said state law doesn't give election officials any leeway to police the eligibility of presidential primary candidates. He also said the case raised a political question that shouldn't be decided in the courts. And his decision was later upheld by the Michigan Court of Appeals, which said the following: at the moment, the only event about to occur is the presidential primary election, but as explained, whether Trump is disqualified is irrelevant to his placement on that particular ballot. And here's legal scholar and professor Jessica Levinson with more on what happened when it got to the Michigan Supreme Court and how their ruling differs from the ruling in Colorado.
This is the question, right? What's the difference between the Michigan decision and the Colorado decision? And the big difference is that the Colorado Supreme Court got to the merits, meaning the substance. They got to the big legal question of what does the 14th Amendment prevent and what does it allow? In Michigan, the court did not. This is all about procedural grounds. In Michigan, there were 2 bases for the decision. The first one was this is a political question. Courts shouldn't be weighing in. So again, they didn't get to that federal constitutional question. The second was that the Secretary of State, at least on the primary election ballot, doesn't have the power to kick somebody off the ballot, doesn't have the power to determine eligibility. So this is a very different decision, not just in outcome, but in how you get to that outcome.
So John, I'm really curious to hear your thoughts on this, because as I shared with the audience just last week, I'm torn on whether it's a good idea to boot Trump from the primary ballots. And I should note that this question is different from whether Trump should be barred from the ballots in the general election. That issue is very likely to come up in the future. Obviously, the Supreme Court of the United States will eventually weigh in on this, and I think that they're going to rule in favor of Trump on this issue. But I'm curious what you think and what you think should happen.
I have thoughts, but I want clarification. So you said you're unsure about whether it's a good idea.
Yeah.
But that's a consideration of the effect or whatever. Do you think based on a plain reading it should be?
I think there is definitely merit to argue that this interpretation of the 14th Amendment applies to Donald Trump, considering that he did carry out an insurrection. It was a failed one, right? But I mean, we have so much evidence showing that he directly was involved in, pressuring election workers to reverse the results of the election. Certainly in Michigan, where we have tapes of him doing so.
In Georgia.
Yeah, and in Georgia, we have evidence of the fake elector scheme. I mean, the evidence is there, so I do believe that there's merit. I think that's an entirely different question from the political one. And what I mean by that is, I just feel that it would be far better for Democrats to have a robust primary and choose the best possible candidate to beat Trump once and for all. I understand that people are uncomfortable with my take on this, but the reason why I say it is I just feel like it's gonna further destabilize the country and our electoral process.
Sure. Yeah, there's gonna be all sorts of secondary consequences in the short term. There's enough right-wing whack jobs that some of them probably will carry out acts of violence, so that's awesome. But that's the consequence of almost anything happening in America, is you can expect someone's gonna shoot up a Walmart or something. Politically, the consequences, I have been clear about what I think about that. Were Donald Trump to actually be barred from being the candidate, he would be replaced by insert a Republican, and that Republican would beat Joe Biden. I think would have a much better chance against Joe Biden than Trump. So if I came out on the side of he should be barred, it is definitely not because I think that would benefit my preferred candidate or whatever. My preferred candidates aren't allowed to run at all. So it's not that. I think the merits are very interesting, but I think there is so much ambiguity. Some of it was hinted at in there, and I think the Michigan decision obviously focuses on a very different part of this than Colorado. They're focusing in part on, partially they say the political question thing shouldn't be decided by the courts. I think it's utterly cowardly. Almost everything is at core a political question that other people, you could pass the buck to other people. So I don't like that. But they're focusing on the fact that it's a primary. And I think saying, even if you think that under Section 3, he should be barred from holding the office, that doesn't necessarily mean he should be barred from being on the ballot. And even if you believe that he should be barred from being on the general election ballot, that's very different than barring him from a primary ballot, which is not even like the full official thing. It's a thing that a political party is running. So I mean, should he be barred from holding rallies? Should he be barred from stump speeches? Like, this is several steps away from the actual election. So I could theoretically agree with Michigan and still think that there's something later that he could be barred for. Look, I think at the end of the day, the Supreme Court is going to decide. They're going to decide sometime in the next month, and whether we like it or not, whether it's completely biased or not, whether Thomas recuses or not, that's going to be what actually determines this. And I don't think it's super clear cut.
Yeah, that's a really interesting perspective. Not what you're saying about the Supreme Court. I agree with you on that, and that's a perspective that I share with you. But what you were saying earlier about how this isn't really a clear-cut case and how it's several steps removed from the actual general election.
The office.
Yeah, and holding the office. I think it's a really interesting point. I'm curious what you think about the precedent it would set. Let's say in an alternate reality, and I say that because I really do think SCOTUS is going to rule in favor of Donald Trump, but in an alternate reality where they don't, and they decide, no, the states that choose not to have him on the ballot are well within their rights to do that, considering the fake electors and what Trump did in trying to reverse or intervene in the 2020 presidential election. Consider the fact that Trump, even though he's facing legal challenges for what he did, he hasn't been charged with insurrection, and he hasn't been convicted yet in any of the legal challenges. And I'm talking about Georgia, of course, and the federal case against him in the election meddling trial. Does that concern you at all, considering how Biden has been accused of nonsense with no evidence? He hasn't been convicted of anything. They're trying to impeach him on false grounds. They haven't provided a shred of evidence for it. But couldn't red states try to make the same argument in regard to Biden?
Well, look, as you know, Section 3 doesn't actually say that you have to be convicted of it. It just says that you have to participate in it. Now, theoretically, I'm not a lawyer. It could be that there are clear precedents where the same word has been interpreted in other things as meaning more than just you were there. Maybe participate has often been ruled by the Supreme Court to mean you have to be charged or convicted. I don't know. And again, the Supreme Court is going to rule on that. In terms of whether this will be instantaneously slippery sloped in the red states, I mean, it already has. Marjorie Greene and a representative from Florida and Ken Paxton in Texas are already saying, Kristi Noem are already like, we're gonna take him off the ballot for, I don't know, the border, inflation, something, Hunter Biden's junk. They don't even know. And by the way, anything could be slippery sloped, but in a reasonable country, the wording of Section 3 is fairly specific about insurrection or giving aid and comfort to the enemies of the United States. However, we live in the least serious of times, and so it doesn't matter how specific it is. And again, fundamentally, the Republicans don't care about any of this. They will take Biden off not because they think that the definitions in Section 3 are now more expansive. They'll do it because it'll benefit them at the time. So yes, I have no doubt that they will immediately try to disqualify literally anyone who runs for president.
Well, we'll see how this all develops. This is one of those stories where it's hard for me. Like, I'm split because of the legal merits, which
I'm trying to be fair too.
Yeah,
and we will get no credit for that, by the way.
Of course, we never do, but it doesn't matter, right? This is how I honestly feel about it. There are the legal merits, which I think are certainly there to make the case, and then there is the potential political backlash, which I don't think will bode well for the country, and certainly not the Democratic Party, even though they think that it might. We'll see how it all plays out, but we'll fill you in as this legal argument develops and as other states attempt to do what Colorado did.
If you enjoyed this video, that's because of our members. They make us independent, they make us strong, and they make us honest. Become a member today by hitting the join button below.